morning or good afternoon, viewers, depending where you are. This is the Slarskey LLC series on litigation funding and commercial litigation. In this series, we explore hot topics in legal funding and related issues. Today's episode focuses on developments in the British cost and funding market. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. I've had a footprint in the litigation finance space for over 15 years. Among other areas of dispute, I frequently litigate disputes involving litigation funding, legal ethical issues, sometimes in the context of litigation finance, fee disputes, and I also do risk-based work on contingency and hybrid. Today's guests are experts on legal costs in their respective markets. We have Becca Hogan here today and Adam Hollander. Why don't each of you just give a brief introduction on yourself? Becca?
Hi, Evan. So I'm a partner in the London office of Signature Litigation, which is a boutique firm like yourselves, and we specialize in commercial litigation and arbitration. And I personally specialize in financial services, securities litigation, and group claims. I joined Signature as an associate over 10 years ago, and in that time, we've been instructed on several cases requiring litigation funding or cases requiring unique funding arrangements to help clients mitigate their financial risk exposure during litigation. To give you some recent examples of my work, so we acted for some large institutional claimants in the RBS rights issue litigation, and more recently acted in a claim against Barclays, where Adam was instructed as an expert on matters of New York law for us, and more recently defending a French car manufacturer in relation to diesel NOx emissions claims.
Awesome. And Adam, how about you?
I'm Adam Hollander. I am a partner here at Slarskey LLC. I've been here for about 2 years. Prior to coming here to Slarskey, I was at the Bernstein Litowitz firm doing generally plaintiff side securities class action work, as well as corporate governance work. So representing shareholders in suits against or involving generally large publicly traded companies. And, in that capacity, we were always very conscious of our costs. And what I'll say, just at a very high level, is conscious of costs, not just to the firm of prosecuting an action, but ultimately those are frequently costs to the class, to both clients we represent in a representative capacity on behalf of the class, as well as the absent class members, and always being focused on ensuring that we were properly representing their interests and using resources in an efficient way. And that's something that the court is always going to scrutinize, and thinking through ways to do work that is frequently very capital intensive, while at the same time ensuring that you are using resources efficiently and properly for the shareholders' benefit, for the class's benefit, I think raises a number of really interesting issues that I'm excited to talk about today.
Awesome. Well, look, the focus of today's episode is going to be on the US and the UK cost regimes and risk-based litigation markets. And we're going to discuss both third-party litigation finance and related issues like contingency fees, mass actions, cost shifting, and the like. Both of you each obviously have a focus and background in the securities and mass or class action market. So I really want to focus on that as well today too. Let's start at the top though. Adam, why don't you walk us through the US style contingency fee model, particularly in mass actions, and how that fits into this whole question of funding and costs?
Sure. So I will speak first to what I'm most familiar with, which is securities class actions, and in particular, those tend to be opt-out class actions. So rather than presenting a class but needing class members to come and opt in, once the class is certified, generally, you have a very large class, and it's up to any individual class member to opt out, as well as if they want to object at some point to a settlement, to a fee award. But, I would say that thinking about funding and financing is something that really from the very beginning of a case you're focused on, and there's a couple reasons for that. One is certainly when you're talking about a large deep-pocketed defendant and a case with substantial damages, you are looking at an adversary on the other side who's going to be really well financed, right? And able to generally put a lot of resources just to make you litigate more, litigate longer, litigate harder in the hopes that it's going to wear you out and you're going to ultimately, kind of settle for not as good of a deal as you might otherwise. And so funding and financing being really a key way, not just to ensure some access to justice, but to ensure almost a fair playing field. Now, most of the large class action shops here, or at least many of them, do self-finance, and they're able to self-finance through historical successes and have a bit of a war chest, or they have, good relationships with banks. And so I am less familiar with going out and getting third-party litigation funding. But that said, I think it's increasingly the norm, or not the norm, but increasingly available. And I think there's good reasons for that in terms of spreading risk around and in terms of making sure you're not going to hit some roadblock at some point where suddenly the funding dries out and you have, expert fees coming up or whatever it is. That said, there's still always going to be an accounting at the end of the day. If you're settling a case and you're going and you're asking the judge to approve the settlement, particularly as being fair and adequate to the absent class members. So thinking through not just how do we get the financing, but is that an expense? Is that coming off the top? Is that coming out of a fee that may be awarded to the lawyers? And is it defensible if you have some objector who shows up at the end of the day and said, you got this third-party litigation funding, you disclosed it when you asked for approval of the settlement, and I think you could have or should have gotten a better terms. So you didn't do a great job for the class here, and we're going to object to the settlement, we're going to object to the fees, and we're going to drag things out that much longer. So really, always being focused on that question of funding, although I think in a different way probably from Becca in the UK, where it is, really the loser pays system that we don't have here.
Yeah, I mean, look, the US litigation finance is obviously relatively new, and the rule forever and ever has been that if XYZ law firm, be it Bernstein, Litowitz, or somebody else, really likes lawsuit, they can take it on contingency, bear that risk, and maybe do some stuff with it behind the scenes or not behind the scenes. But it really all begins with the contingency fee model. Becca, why don't you walk us through the UK and what's gone on in the UK historically, and specifically the availability or non-availability of contingency fees and how that dovetails with litigation finance?
Yeah, sure. So there's essentially two main mechanisms in the UK. You've got contingent fee agreements, CFAs, where you can have either 100% uplift on what you charge. You can do it on a 100% CFA basis, and then you're limited to uplifting that by 100%. Or you can do it on a DBA, a damages-based agreement, where you take a percentage of any damages received. There's pros and cons to both models. CFAs have been around much longer. They've been around since the 90s. DBAs only came into play in 2013. And resonating with something that Adam said, they were introduced with a view to making litigation more cost effective and efficient. They were sort of part of that reform package. Whether that's been achieved remains to be seen, I think. But in terms of the two options, what we typically see in the UK, we see more CFAs. So we don't see much of the self-finance work in terms of law firms. So typically you'll see a CFA where the law firm will agree to act on a reduced standard hourly rate basis, where you might pay something like 70% on an ongoing basis with 30% deferred and conditional at the end. And then that 70% is typically paid by a third-party funder. So you'll need to go out and get funding to pay that 70%. And that's a sort of quite a common model that we see over here. It's relatively well established now. It enables a degree of risk exposure for the law firm. It also is better for the funder because then there's a sort of risk spreading in terms of everyone having a degree of skin in the game. But those are the two most common types of structures we see. There is a third, more new sort of development coming in, which is litigation finance, where you see law firms entering into a portfolio arrangement with litigation funders or financiers So to give you an example, there's Amnesty. I don't know if you've heard of them, US hedge fund,
Sure.
who have put $500 million into the law firm PACCAR, and that's said to be not your sort of traditional third-party funding, but that's essentially a loan which they can call in. And I mean, we don't know the full details of it, but the basic principle, as I understand it, is that loan is protected, or there's a portfolio arrangement where it covers all of their cases. And so, they may get a recovery based on any one of the cases that they've got running, including in the diesel NOx emissions claim where they're on the other side of us.
Great. It strikes me that in the US, we've had contingency fees and risk-based litigation forever and ever. It's been a meaningful part of the litigation footprint here, be it personal injury suits, securities class action, consumer or otherwise, patent litigation. No matter what way you slice it, it's always been a meaningful part of the US market. And the UK is only now really leaning into some of these areas. Becca, how have you seen the UK appetite for US style mass actions evolve in the past, call it 10 or 15 years?
It's 100% a growth area. I'd say in particular in the last 5 years, we've actually seen US Plaintiff Council coming over here and setting up shop, if you like. So Mark Lanier, the Talkman, and various other Pig's Good Head, for instance, Harris Hogan setting up. So there has been a real shift to sort of trying to bring the US over to the UK. Whether that will really explode in the way anticipated, I think remains to be seen. And as Adam indicated earlier, one of the key differences between us is that the cost shifting, the adverse cost position here, which I think does provide a check on the sort of anticipated explosion of US style class actions over here. But to give you an overview of how group claims are structured, well, there's a few different mechanisms. The one that most people like to go for is the opt-out competition appeals tribunal cases. And obviously everyone wants to go for opt-out because I'm sure all the reasons you're familiar with in terms of the difficulties with book building, claimant apathy, and engagement with claimants can be challenging. And so if you're opt-out, it's much easier. What we've seen over here is people essentially sort of shoehorning or pushing the envelope of what would traditionally be a competition claim in order to get within that opt-out framework. The other mechanisms are representative claims under CPR, Civil Procedure Rule 19.8. That's the closest thing we have to opt-out, but it's notoriously difficult to establish the same interest. Then you've got group litigation orders, which are opt-in, challenging for the reason I mentioned earlier in terms of book build, engagement with claimants. And then you've got other structures like where you don't have the sort of formal GLO structure, but in the Barclays claim, we had, I think, 130 institutional claimants, and that was just sort of case managed by the courts without that formal framework.
Great. Adam, you sit in a really interesting seat where you've lived and breathed this for years in the US, and now you're working in the UK, helping some of these firms really build their practice in this area. Sitting in your seat with a view into the UK mass action world, what similarities and differences are you observing?
Sure, a couple things. So one is, and this is also a question I had for Becca, thinking about if you have to go and you have to spend substantial time and resources, essentially signing up individual class members, and that may look very different in a consumer case versus, a securities case or other types of matters. What does that process look like in terms of financing it? How is that built into a budget, and how does that affect the way that you are thinking strategically about both prosecuting your case, getting to a good result, and kind of the life of a case might look like, and for that matter, potential returns? So I think that's one real key difference is if you have to really spend that time. And look, we have plenty of types of class actions here in the States where there's a lot of work spent on kind of rounding up class members to opt in. So I don't want to suggest we don't have that here at all, but it does probably impact the amount of financing you need as well as the types of arrangements you might enter into. So I think a lot about 10 years ago, there was a circumstance down in Delaware where it seemed like for, I don't know, a bit of time, companies would be able to amend their bylaws to add
Mm.
fee shifting into their bylaws. So if you're a Delaware incorporated company, which is a substantial number, probably most, particularly large publicly traded entities here in the States, but others as well. You can put into your bylaws a fee shifting provision if there is shareholder litigation, and that could be in Delaware, that could be not in Delaware, right? That could be a governance, a fiduciary duty case, that could be a securities fraud case, that there'd be essentially a loser pays provision. And ultimately, the legislature was able to, with a lot of kind of good lobbying and input from the bar on both sides, come to a rule that didn't impose those provisions, or that, for big companies from putting those in and enforcing them in ways that would really have a chilling effect on shareholder litigation. That's a long way to get to the point, which is there was really concerted effort to push back on that. Maybe it's obvious, but the idea of having loser pays staring you in the face did potentially have a very chilling effect on firms that are generally excellent lawyers, have great track records, are not shy about taking shots and risk exposure. And yet still that was potentially maybe a bridge too far. And I think partly there was not at that point, especially the type of litigation finance industry that there is now in the States, as well as insurance products and other products to help law firms mitigate the risks they might face. And that's a long way to say it's really a question for Becca, I think. How does your firm, or how do other UK firms navigate that question? I guess, to some extent, the loser pays is kind of baked into the model. How many
Loser
cases do
pays
you not
is,
take because you do a risk assessment and it just doesn't reach whatever metric you've set to justify
mm,
taking those risks, or for a funder to justify
yeah.
taking?
So loser pays is, it's the only thing I've ever really known. So to me, it's a fair system. Obviously, it's alien to you guys, but the basic principle behind it is if you pursue litigation and you lose, then you put the other party to huge expense that they wouldn't have otherwise had to bear had you not brought that litigation. So in many ways, it does act as a good check before you decide to go off and start litigation. And equally on the defendant side, if you lose, again, it's the same principle. It's about balancing the interests of fairness. But to answer your more specific question, it does depend on a number of different factors. If you're starting a claim and you're trying to book build it, technology has definitely helped in the last 10 years in make that book build more economic, and therefore if you get to the sort of target a quantum base or target claimant base, you're sort of, until you get to that point, it's slightly, you're in the sort of no man's land of not sure whether you're going to be able to build a claim of enough value to make it worth pursuing or not. And so there are various different structures you can do. Some funders might be willing to invest, a couple of £100,000 in order to fund that book build exercise. So you can go through that sort of exploratory phase or trying to go through the book build. And if after you've spent that initial investment, you haven't managed to reach the target quantum, then you'll sit down with a funder and they'll decide if they want to continue it or not. Or another option is the law firm may decide it wants to invest its time and agree to do the book build on 100% contingency fee basis. But there's a few different options, and technology has definitely made it easier for those types of claims to get off the ground. But you are always in that sort of zone of trying to reach the target quantum to make the whole thing viable, whilst not wanting to invest too much on what is essentially a speculative claim until you get it to the requisite threshold.
Okay, so we hit on an important point here, right? US, we have, generally speaking, no fee shifting, got gunslingers like Adam taking his shot, act now, think later. In the UK, where not only the client but the funder as well can be liable for adverse costs, there's a little bit more work up front. How about disclosure? Becca, what is the UK approach to disclosure of third-party litigation finance?
I'll just go back on what we were just saying, because you've actually raised an important point, Evan, which is because of the adverse cost risk, when you're trying to do the book build or start a claim, you have to be able to say to those that you're joining up to it, this is no risk to you. So you have to have in place sufficient adverse cost cover insurance, and you have to be able to offer that whole package. Otherwise, you're never going to be able to get people to sign up to it. So
Right.
that's another upfront cost that you have to bear in order to go through the book build. On your second question, which I've forgotten what it was.
Disclosure. Why don't we walk through the
Disclosure, thank
differences
you.
between the disclosure of litigation finance in the US versus the UK?
So in the UK, the short answer is there is no rule which says that the other party is entitled to disclosure of the funding or finance agreement. The long answer is the reality is that you can pursue that relief from the court, given if the funder is obviously funding the claim against you. As a defendant, you're entitled to seek security for costs against your opponent. And typically in group claims, it's too administratively burdensome for the defendant to go after, 30,000 individuals for its costs, and the court recognises that. And so where those claims are being paid for by third-party funders, essentially the funder is on the hook for those adverse costs. And so as part of that issue, the defendant is then potentially entitled to obtain a copy of the funding agreement if the claimants haven't been able to satisfy the defendant that they've got sufficient insurance cover in place to cover their costs. So if they haven't got insurance cover in place, then you can then apply to court for disclosure of the funding agreement, and then that may lead to an application against the funder directly for security. And it is actually possible to join funders to proceedings for that limited purpose.
And Adam, what about the US? What's the US general tone as to disclosure of third-party litigation finance?
It's a good question, because I don't know that I would say there is a general tone. It really does seem to vary jurisdiction by jurisdiction and sometimes even case by case. Perhaps kind of more broadly applicable rules or practices would be helpful. As a general matter, I think courts are still wrapping their heads around what does litigation funding look like and what are its implications in terms of legal ethics, in terms of who's making litigation decisions, in terms of whether it's necessary or valuable and what that looks like. There are certain courts like the Federal District Court in New Jersey that require disclosure right at the outset of any third-party funding. There are certain courts, like federal courts out in California, where if you are asking to approve a class action settlement, aside from the settlement agreement, you're required to disclose essentially any other contracts or agreements, and arguably that would include funding agreements for the purpose of kind of scrutinizing, are the class's resources being used properly? Is it an adequate and fair settlement in light of that? The same way a court would review, maybe any other cost or any other issue that may raise questions about adequacy and fairness, right? Were you settling the case because it was the best deal you could get for class members, or were you settling the case because the funder decided it was time to, get back what it could on its investment and move on? The other thing that we see, I think, here most frequently, although not exclusively, the funding is on the plaintiff side. You see defendants in discovery making a number of demands for any information about any third-party funding agreement, and they'll argue it's relevant for a lot of the reasons I just discussed. And if you think about it, the third-party funding could come from kind of an established shop that either focuses on third-party funding or has a more traditional investment portfolio. But there are also instances where it could come from, a competitor, right? I'm suing company X, and company Y, that's the competitor, is directly or indirectly funneling money into the case. Certainly that is, interesting, and you can understand why company X would say, we need to know who's paying for this litigation. It has very real implications for all the ethical issues that are underlying this. And I think some judges are getting more educated on litigation funding, how it works, why sometimes it's important or necessary. But there is probably a healthy skepticism from folks who have been exposed to it less. The last thing I would say, though, is some of it strikes me, particularly from the defense side, as a bit disingenuous at times. I mean, I understand you're an advocate and you're looking for any strategic advantage you can or tactical advantage, and this is a pressure point. At the same time, when you have, at some firms, lawyers who are billing out at as much as $2,000 to $3,000 an hour and up, the idea that their clients somehow ought to know, are you getting funding and how much funding are you getting and what does that look like, when really it is increasingly becoming, I think, the cost of entry to maintain a level playing field in certain types of cases. It does make you scratch your head a little bit, right? Because we're not entitled to information about fee and who's paying them, right? And there could be any number of sources of funds that might raise some questions on the defense side, and usually we wouldn't be getting that information.
Yeah, I mean, my observation is that just about every jurisdiction has found in the ordinary course of litigation in the US for the agreement itself to be irrelevant. However, it does pop up, certainly in the case of class certification. And I've seen it a couple times in class settlement. Becca, how about on your side of the pond? When do these things typically inject themselves? Typically, is it part of the settlement process or the court approval process at the end? Do these issues kind of creep up? And what do you find the judge's level of understanding to be concerning litigation finance?
There's two main periods in which it might crop up. So typically fairly early on in a case, if the defendant's seeking security for costs. So as I mentioned earlier, you can seek that fairly early on. In fact, the defendant might be penalised for waiting too long to seek security for costs. And so in a case I worked on a number of years ago, the RBS matter, there was a security application and it was heard, I think, a month before the trial was due to start. And I remember being in court all day and then having to go back and then work another full day on our opening submissions. It was quite an intense day. But in that case, that was related to asking the funders to put up security. And that was quite an interesting one. And it actually resonated with some of the things Adam was saying in terms of the sort of commercial aspects that sit behind it and the ethical parts of it. So in that case, there were two funders, and the bank was successful in getting security against one of the funders, which was a commercial funder, doing it for sort of commercial gain. And then the other funder, who was actually a claimant in the proceedings itself, and essentially a family office, they were doing it because they realised that money needed to be put in to enable the claim to continue. And that funder wasn't required to put up security. So that was quite interesting in that, that very same judgment to see the two different approaches. And then, the other period in which it might crop up is in settlement, as you said. So as to whether or not it does crop up depends on the structure of the proceedings. So if you're in an opt-out situation in the CAT, then the court will expect a degree of information about where the funds are going, where the settlement monies are going. So to give you an example, in the very recent MasterCard settlement on the interchange fees case, and that was in the Competition Appeals Tribunal, that was a settlement for £200 million, 100 million of which went to the funder, and the remaining 100 million goes to the class, I think giving them something like £2.60 per claimant. The court looked at it, the courts approved it. I mean, I don't know, I haven't actually come across an instance where the court has said, no, we're not going to approve that. And in that case, to put it into context, the funder paid out, I think it's £46 million in legal fees, expert costs. These CAT claims are extraordinarily expensive. And so the funder there got, a one-time return on its investment, essentially. And that case is particularly interesting because as part of the package, it's been reported that MasterCard has actually paid or set aside £10 million for the class group to have a fight with their funder, because the funder wasn't happy about its recoveries. So MasterCard has put aside some money for them to have that dispute.
So let me ask you a question on that. Is that payment to the funder treated as an expense? Does it just come out of the fee that would have otherwise been awarded? Does it come off the top?
So as to whether it's an expense, I don't know is the answer. I think it's essentially a cost-inclusive settlement, and they then taken that to the court and said the overall sum is 200. This is how it breaks down, and to give the court some oversight, because it's entitled to oversight because it's opt-out.
One thing I'll throw out that's kind of interesting is the US, for the most part, the courts have extricated itself from these types of discussions. Adam, I'm not sure if you saw this, but there's the Perez Rash Curtis case. It's a Northern District of California from just 3 years ago. And that's really interesting. It's a situation where there was a class action case. I think it was a TCPA case. And the law firm had taken it on contingency, borne the costs, everything like that. Then they had this big settlement and they come in and they say, well, actually, we had securitized a piece of this on the back end to a funder. And as part of this class action settlement, we want that to be considered an expense of the litigation. The court said, nah, we're not going to get involved with that type of thing. If you want to go, law firms finance themselves in all different types of ways. And in the US, at least, the law firm bears the cost of it. If they want to do something on the back end, that's their business, but that's not something that we're going to get wrapped up in.
Right. So I have the language from that decision open here. I won't read the whole thing, but to your point, and this comes from that decision, many plaintiff firms self-finance and presumably have complex lines of credit with financial institutions. To allow such an expense here, such an expense being the cost of funding, might suggest that other class counsel should or could request reimbursement for their own financing arrangements. Thus, the court is not inclined to approve costs which fundamentally relate to the cost of doing business. To the extent those expenses included fees for legal services, that portion is addressed below. And so I think that does raise an interesting question, or a couple. One is, and you two are maybe more familiar with this than I am. I mean, what is the market for bank loans or more traditional financing as compared to the litigation funding industry that's still developing a bit? I mean, presumably, any of our firms would rather go borrow money from a bank at a more reasonable rate than what funders might be demanding in return. Is it that the products aren't necessarily there, or the banks themselves aren't comfortable with that type of risk without having some sort of proven track record? Because I think this decision in the Perez case, it's a fair point, right? We all have to fund our work somehow, whether it's through hourly fees in other cases or borrowing money from a bank or whatever. That's the cost of doing business. Why does that come out of, particularly in a class action, why does that come out of class members' pockets?
Well, look, I'll say my quick observation is in the US, that seems to be the general thought. And for that reason, there are plenty of specialty finance funds that will go out and do these portfolio financings with individual law firms. And they're still quite expensive, right? But they are cheaper than one-off litigation finance because it's done on a portfolio basis and it's cross-collateralized. In my observation, at least, and Becca, I'd appreciate your view on this as well. In the UK, with the exception of what Becca talked about earlier with Pogust and Gramercy and some of these new portfolio financings, the cases or the funding situations tend to be one-off, and they tend to be a true tripartite relationship between the funder, the law firm, and the claimant, and not as spread across portfolios as might be a little bit more common in the United States.
Yeah, that's absolutely right, Evan. And I think what it boils down to is who bears the risk. And with litigation funding, you'll have a CFA, so you get paid a percentage of your fees on a monthly basis by the funder, and then the remainder is at risk. But the funder is also at risk because third-party funding is non-recourse finance. And so it really does depend on the merits of the case and whether you're going to get a successful outcome at the end of it. And then, on the sort of finance arrangements, it can be more expensive. It's not something that we've done. The other thing that we have seen is where you have law firms have a sort of tie-up with litigation funders. Mm-hmm. Once you do that, then you're kind of limiting your ability to go out and negotiate on your client's behalf. And so we've seen press releases where certain firms enter into arrangements with particular funders. But then a couple of years later, you hear in the market that they're not really working out, to be honest, because you then, like I say, you then sort of limit your ability to negotiate the best terms for your clients.
So, Becca, because we have you on, because we're reaching across the pond here, I don't think we could go without talking about the PACCAR decision. Why don't you walk the viewers through what happened there, why that's important for this discussion?
So in the PACCAR decision, this was a case in the Competition Appeals Tribunal, and it harks back to the 2013 introduction of damages-based agreements that I talked about at the outset. And essentially, this was a Supreme Court decision which said that the funding agreement in that case, where the funder would get a multiple, a percentage of the damages, was a damages-based agreement and therefore unenforceable. The reason it was unenforceable was because it was common ground in that case that if it was considered to be a DBA, then it didn't comply with the DBA rules. So this did set sort of shockwaves throughout the litigation funding market,
Sure.
and it really did have a bit of a sort of, everyone kind of took a deep inhale of breath. Now, I don't think the consequences of it have been perhaps as far-reaching as everyone initially thought. As ever, there's ways around this. So instead of having the percentage of recoveries, you can structure it in other ways. So you can have multiples. Or the obvious other alternative is, if you're going to have a percentage, then make sure that it's compliant with the DBA regulations. So yeah, whilst everyone was very shocked, there are ways around it. Now, I think one of the underlying issues that it did throw up is that the development of litigation funding in the UK has overtaken the legislation and the regulations behind it. And so the regulations just hasn't kept up pace with the development and the presence of litigation funding. And so there's a review going on at the moment, and I think they're due to file a report in the summer. But I think everyone recognises that there's a need for actual legislative change, and it'll be very interesting to see how that plays out.
Yeah.
Particularly with the Labour government that we've got now, I think everyone's expecting it to be a bit more pro-claimant than it otherwise might have been.
Yeah, that takes us into some of the conclusions here. I'd like each of you to give your either conclusions or what your predictions are for the market. I'll start. I mean, you just hit on a really interesting point, which is in the UK, you've had a Supreme Court decision and you've had these Jackson reforms and a series of reforms over the past 15 years that really dictate how the entire market's going to work. What Adam said earlier was, yeah, maybe you have a federal court in New Jersey doing this or some talk about it down in Delaware, and the state courts and the federal courts might be different, but we haven't had that moment yet where you have the Supreme Court of the US come down and say something, or federal legislation that will dictate at least how all the federal courts work, or the American Bar Association say, I know what you guys are saying in New York, and that might be different from what's going on in Texas, but here's what we're going to say countrywide. So that's one of the things that I'm looking forward to in the US, to see who is it, whether it be the Supreme Court, the legislature, the ABA, who knows, who's going to be that first one to really say, all right, on a countrywide basis, this is what we think, and here are the meets and bounds of this whole litigation finance space. How about you, Adam?
I think, look, to the extent there is a public discussion going on or some push for more blanket rules, I think you have groups like the Chamber of Commerce type groups who are focused on this for maybe obvious reasons, right? Their members want to, if not prevent claims being brought against them, and I'm sure they would say, well, requiring disclosure is not going to prevent any claims. If anything, it's going to add transparency and help prevent frivolous claims. I tend to disagree. I think there's lots of really good claims that don't get brought because of resource availability issues. So I'm curious to see if more of the larger plaintiffs' firms begin to adopt financing as a way to pay for their cases more. How does that then raise issues in front of courts or create more of a coordinated response to the defense bar or chamber of commerce focus on more transparency or more disclosure and using that to make things messier?
Great. And our British expert, Becca, what are you looking forward in the next 5 to 10 years in the cost or risk-based model in the UK?
So my prediction is that the claims in the Competition Appeal Tribunal will restrict. I think PACCAR has had an impact on those types of claims because they are extraordinarily expensive to bring, and therefore, in order for the economic model to work, it is typically lends itself more to the percentage-based recovery. And given the uncertainty around the ability of funders to have those types of mechanisms, it's less of an attractive option for those types of claims. So I think CAT claims are going to reduce. I think as a result, there will be more representative claims will try to get off the ground. Whether they'll succeed or not, we have to wait and see. But on the whole, I think in the UK, group claims are here, they're here to stay, and I think we can expect to see more of them.
Awesome. Well, look, thank you both for joining the episode today. Lots of great conversation, and welcome to come back anytime. Thanks again, viewers.
Thank you.
Thank you.